call this meeting to order. Ask you to turn your cell phones off. Rise for the invocation and remain standing for the pledge of the flag. Father, again, we thank you for giving us this another opportunity to come together as a board to discuss the business of this great county that you have entrusted us with. Father, we pray for your guidance. We pray for your wisdom. We pray for your presence to be felt here this evening. In Jesus' name, amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First item, consideration of a resolution to approve the agenda. I'll entertain a motion.
There's nobody wanting to make any adjustments. I'll make a motion that we approve the agenda as presented.
Motion and a second to approve the agenda as presented. All in favor?
Aye.
Any opposed? So carried. Next item, consideration to approve the minutes for the December 3rd, 2013 Fire Station Workshop and the December 3rd, 2013 Commissioners Meeting.
Mr. Chairman, you separate those because I wasn't at the workshop.
Okay, I don't see a reason we can't separate those. Let's consider first the minutes for the December 3rd Fire Station Workshop.
No abstaining.
Make a motion to approve.
I'll second.
We have a motion to approve by Commissioner Loper, second by Commissioner Floyd. Commissioner Kiefer abstains because he was not here for that. All in favor?
Aye.
Any opposed? So carried. Next, consideration to approve the minutes for the December 3rd, 2013 Commissioners Meeting. Motion?
Motion to approve is submitted. Second.
Motion and a second. All in favor?
Aye.
Any opposed? So carried. It's noted that public comments, please, will be limited to those items on our agenda only. And the correspondence documents from this meeting are located in the clerk's office and on the Board of Commissioners website. Next item, we have one item on our consent agenda. That is the consideration to accept the release of sanitation fees as submitted by the Sanitation Department. I'll entertain a motion. Make a motion to approve.
I'll second.
We have a motion and a second. All in favor?
Aye.
Any opposed? So carried. First item under old business, consideration to approve the new travel policy. Mr. Allen.
Mr. Chairman, at your last meeting, this document is tabled because of confusion regarding the version that came out after your book did, due to comments. We seem to find ourselves in the same situation again. You should have in front of you another revised travel policy, which is redlined from the version that's in your book. We received comments recently from the attorney, and I will say that all of them, and Elizabeth's here, she can, you know, have them.
I didn't get the documents.
The folders on up here, if they're in there.
Do our clerk just a minute to get those documents for us.
Casey's driving those out. He say, I believe they're all just grammatical verbiage changes, trying to create proper syntax within the sentences and so forth.
There was one exception to that. I think it was number 13 under Part B. I just struck that one entirely because it was conflicted with other parts of the policy. I think it stated that everything must comply with, all travel requests must comply with the policy, that there would be no exceptions, but then later on in the policy there was a procedure for requests that it didn't completely comply with the policy or board approval of that, so I just struck one in its entirety.
Item number 13, I think you're referring to, said travel and event expenses incurred without prior approval will not be reimbursed.
Correct, and that's still in there. And I know the note said there was two.
No, that's actually 14. 13 says request forms must comply with this policy in its entirety.
It depends on which version you're looking at. The one that came out, if you look at the new version, it's 13, it's 14 in the one that's in the book.
And we struck that because there was a procedure for approval of requests that didn't comply with the policies.
Yeah, without prior approval, will not be reimbursed. You know, obviously, the idea was just what it says. The only other one, Elizabeth, was number 10 on the email that you sent. Travel request submitted to the Board of Commissioners for review shall be approved by the majority of the board in an open meeting after review of the employee's travel request forms. The one that's in there about board approval was the board approves the board's travel.
Okay.
They don't approve the employee travel, so that change wasn't made out. That's the reason why.
Clarification.
Correct. So it's up to the board. You know, you're getting it right now. Obviously, you haven't had a chance to review it. It's all grammatical issues. It's the syntax of the sentences and how they flow. If you want to put it off yet again, we can certainly do so. You should have an email in front of you that actually came from Elizabeth that says what the changes were.
Yeah, so 14, the number 14 is one of the things that's gone. So you're talking about renumbering these things so they're in order. But there's no 11, no 14, no 16, 17.
And why was 14?
No. The email, the ones that don't have numbers, these were comments from Elizabeth. Those are fine. If it was not listed in
This
the
isn't
email,
complete either. This is just suggestions from.
that is, there should be a document.
Right.
Also
If
behind
it's
it.
not listed in my email, then I left it alone.
Correct. The one Commissioner Jones has would have the,
Well, personally, I would rather this thing be rewritten and presented to us. I would rather table it, put it on the first meeting of January, and take action on it so that we're taking action on a finished document. That's my opinion.
and there should have been two handed to you. One's a red line version from what's in your book. The other one is no red line, so you can read the daggone thing. So,
I know, but it's back and forth, so.
Yeah.
If that's good, I'll entertain a motion to table this to our first meeting in January. I don't remember what date that is.
7.
January 7th.
I'll make a motion that we table this to our first meeting in January 7th.
Motion and second, all in favor? Any opposed? So tabled. Next item under old business, the planning board recommends approving an application by SOS Solar for HB Ron for a conditional use located in 1900 Stillwell, Ohio Road to install a solar farm on 5 acres, map number 425, parcel number 5, being in the 3rd district. This has been tabled twice before.
Yes, sir. As you remember, it was passed by the planning board, approved by the planning board with the one condition in September, came before you in October, it was tabled at the request of the applicant in November. It was also tabled by the board. The applicant is here this evening if you have any specific questions for him, and I'm available for questions as well, of course. And this is for a conditional use to have a solar collection farm on agricultural property.
All right, Mr. Shaw. So the applicant is ready now at this time to move forward.
He is here and ready to move forward, and he will be glad to speak to you.
Would you like to make a statement for or against? I presume for.
Open it up to questions and we'll have it.
All right. You've already presented it to the planning board. The planning board has recommended that this be approved by this board with these, with the condition of the buffer.
That's correct.
And you are,
My name is Steve Sherrella. I'm with a company called Inman Solar. We've essentially been partnering with SOS Solar to complete the development of this project. essentially, this is a 1 megawatt.
Come to the speaker, microphone.
Sorry. I'm sorry, I don't have a.
Yeah.
State your name, please, for the record, and speak into that microphone.
Absolutely. My name is Steve Chiarello. I'm with a company called Inman Solar. We are partnering with SOS Solar to develop a 1 megawatt solar farm on the property that's in front of you. It's a 5-acre parcel that we are looking to develop that we'll carve out from Mr. Ron's property. And essentially we will be we'll be building a solar farm, which you see pictures of behind what I've given you. These are standalone systems, be ground mounted. It'll take about 8 weeks to complete the project. We would anticipate being done with it in the middle of March. We'll be employing a combination of local labor and solar-specific contractors in the project. And when it's finished, the project will essentially be very low maintenance, so our expectation is that no one will even know it's there is our goal. As earlier mentioned, we are putting up a green screen along Stillwell Clio Road. The completed project is about 8 to 9 feet tall, and we'll be putting up a green screen that complies with the county's standards for such things. That will be 10 to 12 feet high evergreen, and will completely conceal the array from the road. The system will essentially be there and running for 25 years. It is all the power from the system will be sold to Georgia Power. This has already been approved by them, and so there are no, other than we need to, of course, go through the permitting process with the county. Beyond that, there are no emissions from a system like this that makes no noise, and no harmful radiation or any other health concerns whatsoever. So, like I said, once completed, we would expect it to sit there and essentially go unnoticed.
Do you have any?
Are y'all purchasing this piece of property, or are you leasing?
We are leasing the land.
You're leasing the land. And I'm not clear, this question's for George. Property information given to us, and I guess this was what was looked at by the planning board, is 46.48 acres. Are we giving a conditional use for 46.48 acres or for 5 acres that he's saying that he's going to be putting it?
You're giving a permit or the approval for a 5-acre conditional use. The part that it hasn't been cut off yet. The parcel is 46 acres.
Okay.
The conditional use is just on the 5.
So we would be approving a conditional use for a tract of land to be cut out of 46?
Subdivided, yes.
Okay.
It's already been identified?
Yes.
And all this vegetative buffer and everything can be contained upon the tract of land that's being cut out that he's going to be leasing?
Yes.
And still have the solar array placed upon it?
Exactly. This will be the entire parcel. So it's 5 acres includes the fence around the units and the buffer from the road. And we're using existing Georgia Power infrastructure, so there's no, there'll be a pole that we put in on our side. Other than that, it'll be seamless.
Well, personally, I would have rather had a plat of a piece of property to consider a particular piece of property rather than a whatever it's going to be.
That's what I was asking about, was it already identified, because is this exactly where it's located on the?
It's right on the road, and you want to, I don't know if you want to turn the overhead on, but
It being a conditional use, they can't increase it, or, it's not like it can't go 46 acres.
Right.
Because this is being done under conditional.
it's just being approved for the 5 acres, but it's right on the road. There's a house to the right, and this is an open field to the left on this parcel. There's a pond in the back.
So if this board so chooses to make a motion to approve this, I think the board needs a way to clarify what they're approving and on what piece of property.
Page 4 of 7 in your material shows the overall boundary, and this site highlighted in red, the proposed site. Not survey boundary, but it does depict this.
I understand that an approximate,
It
an
just gives you an
approximate
approximate,
location.
yeah, a way to give an approximation of it.
That could wind up being 5.5 acres or,
Well, no, the application for 5. I don't know.
I understand, but what I'm saying is that whenever they survey these actual boundaries, if it winds up being 5.2 acres, are we, as a board, going to have to look at it again saying, well, it's more than 5 acres?
2 acres, I don't think would make any difference.
It doesn't make a difference to me, but if we approve 5 acres.
Right,
then-
you intend it to be 5 acres,
They have to
correct?
keep it
Yeah,
5 acres.
5 acres.
Right.
It's gonna be 5 acres.
Okay.
And I won't sign a plat that doesn't put it where they represent it.
So this board would be considering approval of 5 acres of a plat to be drawn and presented towards your approval.
Correct.
Okay. So this board's giving you the authority to do that at some point. Okay.
Correct.
Do you have any other service volunteer in the state of Georgia?
We do. We have done 5 of these identical sites just this year within the same Georgia Power program.
What's the closest county?
Closest one was, well, they're essentially, we are based in Atlanta. We've done 3 in Polk County, Georgia, which is in the north, Polk, which is near Rome, sort of northwest corner. And then we've done 2 in Marion County, which is near Columbus. So unfortunately, our projects are not necessarily nearby, but
Now, were those done as conditional use also, or were they rezoned?
every county is different, of course, and so we will essentially work with the county but in the case of one, it was rezoned, and the other one, it was already complied with the existing zoning.
Was it rezoned to industrial?
It was something to that effect. I don't know their exact designation. I think they have a manufacturing designation in Marion County. But I will tell you that the trend across the state is more towards the exact use that you are, the exact process that you guys are going through here. We are, this is the second year of this, this is actually part of the first year of Georgia Power's program. This coming year, the program will be twice as large, and so we are hoping to do 10 or more projects this year ourselves. Most places we're talking to are looking at exactly what you're using, agricultural land with a conditional use permit, and what's more, the state is looking at a provision to allow this in a conservation easements area as well. So this is certainly the direction that is going statewide.
How are the improvements on this property taxed counties? How is is there, what kind of money, are you allowed to share that, what type of money?
I don't mind. It's, for this property, we will actually had a conversation with John Henry to see if they would be open to giving us some abatement support, which turns out they're not. But this project will have apparently a net present value of about $200,000 to the county.
200,000. Do you know how that's? So that would just be shown as improvement to the property.
It's
homeowner,
basically
property owner.
It will be to the property owner, which will be ourselves. So
You're going to be the leaser.
Yeah, you're leasing. It's on this individual's property. So
no, there's 2 components to property taxes. You've got the land value, which will not be significantly improved because this is, although it's a permanent fixture, it will be removed at the end of its useful life. Then there's the personal property, which will be retained by our company, and we will be paying personal property taxes.
okay.
So.
Well, along this lines, I have a couple of questions. The signature on the conditional use application looks like it's Linda or Lydia Ashton.
Yes, she is a member of SOS Solar, which is our partner in this project.
Okay, so George,
Yes.
the application is not normally signed by the property owner?
Not necessarily. An applicant does not necessarily have to be the owner. In many cases, especially for minor rezonings, the applicant will be a child or other relative that is going through the process for their parent, often case. And so the applicant is not necessarily the owner. The owner has to sign the ownership certificate saying
So I
that
did see that.
Yes,
I mean,
that,
somewhere, it would be, I'll just say it would be my recommendation that somewhere we get the owner of the property to sign the application also, that they're concurring with the application process.
the ownership certificate is part of the application.
Yeah, they're saying they own it.
Yes.
But we want something saying that they approve it. In other words, this property is in Cuba. Does this affect their Cuba at all? And if so, has that been explained to them?
It will probably breach their Cuba from what I understand.
Do they, are they aware?
I have not spoken to Mr. Ron. Have you spoken to him about that?
We have, and per our agreement, we are, this property also has some back taxes owed, so part of our agreement is to pay the back property taxes as well as whatever fees are associated with
To buy it out of Cuba?
to taking it out of Cuba.
Do you already have a signed lease with them? Because it's
I
not
do.
here.
I have a copy of this here, if you'd like to.
Is it signed?
It is.
Okay. And those would be my recommendations, so that we don't get into the same type of situation where we got somebody saying that they could have moved home there, but they didn't know they had to bring dirt in. And
So the net impact to the county here is this is going to break the Cuba covenant. So where this property has been being taxed under the Cuba covenant, the property of itself will be taxed differently
the 5
with
acres.
this, the 5 acres.
So what we would anticipate is we'll pay effectively close to over $20,000
Yeah.
to the county to remove this from Cuba. So that's an additional value to the county. And then
That is
the
good.
5 acres will be subdivided from the 46, and then the 41 or whatever remains will be put back into Cuba, and the 5 will remain in this conditional use.
Well, the whole reason I asked the question was because if you had not agreed to pay that,
Yeah.
and the sellers were unaware of it,
No, I
they
understand.
came before us at the next meeting.
Well, I'm sure that was all negotiated as part of what you're paying them for the lease.
It is. It's in addition to the lease, and I believe that's clearly spelled out in the lease that you have. I've given away the ones I had, so I can't look at it, but it's certainly clear to both myself and Mr. Ron.
It's probably totally irrelevant, but why would you not try to negotiate and purchase this land rather than lease it so that you're protected?
I mean, we certainly, there's several parties involved in this, okay? So Inland Solar, as a solar developer, essentially is partnering with SOS Solar, who is essentially the founder of this deal, if you will. So they put this deal together. We are picking up the loose ends and getting it across the finish line. There are a lot of people who are doing solar projects who are maybe not as qualified to do it as others. We would certainly not count ourselves among them, and we gladly give you references to the counties that we're working in.
Any other questions?
I'll say one more thing. I mean, this is in my district, and I have had no comment about this at all, no negative or no comments at all. I've had a few people ask me, about it, but it's not like they were really strong for ordinance. So, the buffer is a good thing. I think that really makes a difference right now.
No other questions?
My only question is, at what point, what are we going to allow industrial commercial uses on agricultural property as a board? I mean, we're kind of, it gets slippery slope. And I'm not opposed to it, I'm just throwing that out there because it is a consideration.
It's power generation, which is typically industrial use.
But
We get back to the same things now. There are people putting solar panels on their houses and it's in residential areas.
I mean, from what I have read on it, Mr. Steve there is exactly right. It's trending to be that this is what's been acceptable or accepted routes is the AR zoning. And I understand arguments on both sides of it, but I when we set the policy on approving this in AR zoning, that's when we beat that out pretty good. But I still fall on the side of I believe it's in the right zone.
Did you do?
Yeah.
collect for the improvements.
Well, and 9 times out of 10, it's going to break the covenant, the Cuba covenant, and then the remaining land will come back in, I'm sure, you know, in a new one.
Pretty steep already.
Yeah, it is, and in this case here, I know the owner, because I talked to the owner on this, he told me that it was $20,000 or so. So it's significant. So I know that he's, you know, worth this, but I do know a little more of this story too, firsthand, and this has been, why it's been tabled so many times is because it has been a legal challenge for them to work with.
And then the other thing is, as far as, I don't think we want to get in the business of going out and spot zoning pieces of property out in places like this for industrial. Question? Third district, I'll entertain a motion.
Being in my district, I'll make a motion to approve. Second.
Second, all in favor?
It's a public hearing.
Oh, thank y'all keep me straight. Is there anyone else here that wishes to speak for or against this rezoning?
Conditional use, not rezoning.
Conditional use. And by the time I get this all straight, it'll be time to read. All right. I have a motion and a second. Now, all in favor?
Aye.
Any opposed? So carried.
Thank you very much.
You just need to, as I understand our conversation, you're going to actually plat out this piece of property and take that plat that's going to be no more than 5 acres to Mr. Shaw for his final
That's correct.
seal of approval.
Absolutely. We just, at this point, I didn't realize it was a requirement of this meeting, but we've got it surveyed and it's certainly ready to go.
Good deal. Thank you, sir. Appreciate you coming. Appreciate your investment in Effingham County, sir.
You need your lease back.
You need these,
The press is following you.
the leases?
No.
Did you get a copy? Did you need these copies of this lease?
Just copies.
Okay.
Did you get a copy?
I can remember this first one.
What is the
I can
name?
give her a copy of that.
All right. First item under new business, consideration to approve the job description for the position of county administrator. Good evening, Ms. Rush.
Good evening, how are you?
Right.
Happy holidays. Okay, we are seeking approval from the board, of course, to update the job description of the county administrator. We've given you a draft. These are both in draft version right now. First of all, there's a draft that you will see a lot of strikes and other pieces that are written in red to show you the changes. These were the changes that were recommended during your workshop with ACCG. Mr. Kovac, Mr. Allen, and myself have all re-looked at that, taken our notes, kind of gone back through to see, made sure we caught all of the suggestions that were made. Then we've given you another draft, which basically takes out all the red and puts it in a little bit more order of flow, to give you an idea of what this new classification and job description for county administrator actually entails. What we're looking at for tonight, if you would like to move further, you have 2 options. You can, of course, approve the draft, and then we will update it for you. Or we can look to adopt a different option where you can make continuing suggestions to make sure it has the expectations of what you want as a board, and it's going to be clear for candidates submitting an application or a VTA to you, depending on what version you're going to go for. So with that being in mind, staff is looking for direction on how you would like us to proceed.
But in your opinion, after you told me all the staff that's looked over this, all of the conflicts and all have been addressed and everything has been dealt with?
Yes, all the suggestions that were made through the workshop are here. What we don't know is if there's something specific that the board may want. You have some very different ideas of how you want the administrator to report to you and how they may report with staff, and we want to make sure that those are here before we move forward.
All right, so this job description, is it going to be all-inclusive, or would it be something that could be supplemented by the contract? Is our goal to make the job description all-inclusive, so that the only thing that we have to do when we contract is to simply put severance and things such as that in, and refer to the job description?
Yes, sir. My suggestion is to get this job description as succinct as you can with the expectations that you have, realizing that it can expand, and if you'd like to expand the description itself, you will be able to do that. Your contract is going to be your terms of employment, and that's a little bit different.
Okay. So it would be the board's best interest to be sure that this job description is all-inclusive as close as possible.
Is everything that can, at this point, that you would like to have in there and represented as specific job task, and reporting structures and how you want it put together.
So with that clarification, I would ask each of the board members to poll in as to whether or not you're in agreement with this as written, or is there changes that you would like?
I'm against it. There's 2 or 3 things that I don't. First of all, from what I understand of it, and I've read it a couple times, as a county administrator, but everything in here is for a manager, and that's not what we wanted.
Well, it's still very much, it's your choice to how you want this. We kept it county administrator, but there are some management functions. Now, some of them have been removed, some of them have been expanded, and you're right, there's still some management pieces in there. So do you want us to strike all the management pieces, and we can't do that?
Well, that's what I would like.
Yeah, could you go to the one that doesn't have the highlights? I think it'd be easier to follow. And by that, I mean, that's starting.
That's where I'm at.
Okay, so go to the draft without the
What
highlights.
you don't like, we can start taking notes.
The first one I got is under performance of duties, and this is on the one that, the new one.
Page 7.
Page 7.
Page 7 of 10, yes.
I have no idea which.
But it goes on and says, except for the purpose of formal inquiries and investigations, deal with county employees subject to the county administrator, direction or supervision solely through the administrator. So what that tells me, we can't talk to the employees of the county. If we want to talk to the employee of the county, we got to go to the administrator. But then on the other hand, all of us is liaison between the different entities of the county. So that just kills that altogether. So that needs to be struck completely. I disagree with that.
Is that what it's supposed to be
I don't
saying?
believe that's the intent. I believe it's the direction and supervision solely through the administrator. It's that the board doesn't directly supervise or administer an employee. I don't believe it's saying that you shouldn't speak with them. And this is one of the things that they
Except
will.
for, under formal
Except for-
inquiries or investigations, deal with.
Let me back up. That wasn't the intent. That was never the
But this
intent.
says unless it's a special something that we need to talk to them, we cannot talk to them. And we don't need that. For this department, one condition is that, we liaison between the different.
I don't have your book and page number, so excuse me.
Page number 1, and then on ours, page 17.
This is 7 of 10.
It's under performance of duties.
These last 2 sentences.
Okay, I'm with you. Thank you, sorry. I'm on page 1, you're on page 7, so it gets a little bit.
I would agree that probably needs to be reworded. I don't
Okay.
like the wording of it as well, but Reggie, I would disagree in that each of us as a commissioner have the right to go to any employee and supervise them in any way.
Yes, I agree with that. I'm not,
I mean,
this does not say supervise, it says
Deal
speak
with.
to them.
deal with.
It says deal with.
And that's a bad wording, but we.
These are the original words, so we can update any way we like.
Yeah, and again, that wasn't the intent. We didn't certainly.
But we have, every commissioner sitting here, we are liaison with different entities of the Effingham County. every one of us is over the liaison. So, I mean, I had people call me. I said, well, I can't talk to you, you have to talk to my administrator according to this. That was not right.
Yeah, we don't direct, but like somebody calls you with a road problem, and I'll shoot Jerry an email, I'm saying he sent some leak having to call Toss. I
Yeah.
copy Toss, but that's how they do it, check out this road or ditch or.
Yeah, that's right. That's right.
In my
Well,
opinion, that's a large chunk that sits under that job task, and it can be broken down to exactly what you're saying. You can have the direction and supervision be under your administrator, but you can put a liaison piece and all of that with you. So there's no, it's addressing the concern that you have, but that's a way to split that, because you have a huge paragraph at the beginning of this, so.
But if you change the wording of that,
It's more of a job classification for a commissioner, but, because it's actually addressing what the board member is gonna do,
Yep.
not what the administrator can do.
Exactly.
Shall do.
I understand.
Maybe the way it's worded, a lot of it.
Okay,
I think there's just several little items in here that
that's,
we might need to look at a little bit of wording on. And
well, I got another one also, I think the only one I have.
Well, while we're on page 1, or 7, the access liaison, I think I talked with Commissioner Keefe about this, between the board and other elected officials. What, I mean, I want to be able to pick up the phone, call whoever other elected official I need to without going to the administrator as well.
Well, I think what Phil said a while ago is actually a very good point of what we're looking at. We got to look at this is from the perspective of this is what we're telling the administrator we want him to do. Not that it's going to limit us from doing that, but we don't want him to say, no, I wasn't hired to talk to the elected officials, you know what I mean?
well, that particular sentence says he acts as a liaison, and he often will act as a liaison in that position. And as long as it doesn't have that additional sentence that says, we don't deal with.
Right.
It's not.
Or it doesn't say anything, we're only a liaison.
But there are places that it looks like we're being a little bit more silent, so. But that particular, he acts as a liaison, that is a true statement, but it doesn't stop us from also being able to.
correct,
I'm going to say, it's up to Sheriff College,
We can still.
correct. This
And
is
I think
just,
we're touchy about this because sometimes we've had comments like, you went over there and talked to Jimmy. Yes, I did.
right,
Want to again.
I totally understand.
Yeah.
But yes, it's exactly, if you look at it from the view, you're telling this person when they look at this job description, this is an expectation you have. That does not limit you in any way, but it tells them the expectation that you may have them do this. All right? So it's not your job description so much that they're challenging, it's what you're allowing them to do for you if need be.
Well, if you reword that a little bit, I'll find that.
Okay.
What was your other issue? On the next page, 8 of 10, the third paragraph from the bottom, to appoint and when the direction of the administrator, when the welfare of the county requires it, and adjust to any personnel policy which may be effective or which may hereafter be adopted to suspend, discharge, transfer, or remove all employees whom the board is responsible, except the county attorney, county clerk, information regarding the employee's action shall be made available to the board in a timely manner. Well, y'all, something that pertains to that, y'all struck through it and the one that we already had. And that was the hiring and firing of employees. So all you did was strike through it on the other one and rewrite something that sounded completely different.
Yes, sir.
Well, in the past, the way it was worded was that he had to come to us, it was my understanding, and I don't remember which document it was in one of the documents that didn't coincide to discuss department with us first. But that's been changed here, where basically he has full authority to hire and fire without speaking to us first. And I don't agree with that.
Two things here. I think if y'all could provide clarification, what role does the board want in the hiring and firing? Does the board want to physically hire department heads, or do you just want to be advised of who the hires are going to be? The same thing with firing. Do you want to physically vote to fire someone before termination, or do you just want to be apprised of what's going on? And I say that for two reasons. It depends on how this thing works. First off, if y'all are going to hire people, then we're back and go back to what Mr. Wills was saying when he was here. If you're actually going to do that in executive session, then you have to list up to 3 candidates, give it 14 days, and then vote on it. Is that what y'all want to do? That's question 1. Question number 2 is, do you want to physically vote before you fire someone? And there's two problems, or 2 issues in that. First is, under our current standards of practice, any employee that's terminated has the right to appeal that termination to you. So if they're terminated, you are the arbiter for that decision. So if you are going to vote ahead of time, you've taken that ability away. We'll have to find some other group to arbitrate that. Secondly, the intent of this was to apprise you as that process goes on. And the language may not say that directly, but that was the intent, for the reason that if you are that board that hears the issue and we're in executive session speaking about this, I think you still have a remedy because you've only heard one side. You haven't heard the employee side of that argument. And this was something that Dave Wills pointed out, the reason we struck it, and when he reviewed this, is because this board does, now he used some $100 words that I can't pronounce, but I'll be glad to give them to you, in his recommendation as far as doing that. So again, I think there's two questions. Do you want to physically hire the person and fire them through vote? And if so, we need to do the other side. Yes, sir.
Now stop and
I
think.
got the answer right here. I can't read this, but you read this,
Okay.
and it will answer the question, and everything is in a little simple paragraph here.
Okay.
You read that. It's got two options. Second option right there, you read that, and that will take care of all the stuff that you just said.
We'll read it out loud so that you're all.
That's what I can't have to read it. I have to have a good light to read that.
And this is obviously the ACCG handbook for commissioners, and it's referring to an organizational chart of a commissioner and administrator form of government.
We
It
all
says-
have.
Sorry, yes, it says, as drawn in this hypothetical organization chart, the county administrator will coordinate the efforts of various departments headed by directors appointed by the Board of Commissioners. An alternative commissioner administrator structure would place the county administrator directly beneath the Board of Commissioners in the path, leading to the most department heads, indicating greater supervisory responsibility, and to give the county administrator the authority to appoint and remove most department heads with the concurrence of the commission.
Okay, that takes care of it right there.
And that's fine. Again, we were just, the current job description didn't contemplate that. We were sort of mirroring off the same one.
And concurrence as well.
Yeah, with concurrence, and that's the difference. Is it with concurrence or with the approval of the board? And it doesn't matter to me. I just,
But then, we didn't fire them, so they can still appeal to us.
Okay, we're talking about two separate things. Hiring is one thing and firing as another. So let's do this, let's do them separately.
This that takes care of all of it.
Well, same
person got this.
That takes care of all
With the
of it.
hiring process, for what Commissioner Loper is saying, basically, with reading that means we do what?
You go point or concur.
yeah.
Because what would you, how do you explain what it is we've been doing with departments? Let's talk about that.
I
Have we been
would
appointed
say
or concurred?
concur. I would say this board is concurring. We review, once we do the panels with you, we review the final applicants and ask for any objection that you may have. That's concurrence. Now, if you were to appoint, that's literally your decision to appoint at that point.
Okay, so, and that's what I was trying to do, is get out of the confusion that we're kind of
Sure.
playing the weeds. So
Yep.
I think for the most part, I think the majority of us have still wanted the input, you know, to be in the process of the department head level. So that, you know, if the department heads weren't just hired and then here's who we hired, but that we had some input during the process.
And that's exactly what that says. If he
Yes.
wants to hire some tomorrow, all he's got to do is get permission, a free commission, he can hire who he wants to.
We wanted to keep that the way we've been doing
And if
it.
he wants to fire Adam tomorrow, he can do the same thing.
I'd rather he not.
I'd rather
Well, I
he,
know it, but he can do the same thing. If he gets the concurrence of free commission, then he can do that. And then if he wants to appeal, he has the right to appeal to the commission, because we did not fire him. He did.
So was the board like concurrence for the appointment of department heads? Meaning in executive session, the telling of a personnel decision or the recommendation of it?
You wouldn't have to do it in the executive session. He can call you on the telephone.
Concurrence and
He
appointment.
can call free commission.
We're still talking
We
about
want to stay,
different things.
we're still-
We're on 6.
We're talking about hiring and we're talking about firing.
But
We're talking about, let's deal with one thing.
that covers both of them.
We were over here talking about hiring and you back to firing. So let's talk about hiring first.
That covers both of them.
Okay?
As far as the hiring does go, if we keep it as is, and I don't know what wording you need in here in order to keep it as is, but I think that's the goal, and if there's somebody that feels differently, we want to have the input, and it's wise to have that input from us, because if you end up hiring somebody that four of us just do not want to have in there, it's going to be a problem. So, you know, then the same thing basically with termination. How do you want to look at that?
I think concurrence is the key word there.
Yeah, if before he hires anybody, it's got to be approved by commission. And
So
if he
figure out what-
fires anybody, it's got to be approved by commission. That's simple as you can get.
I would use
Commissioner,
concurrence.
point from the handbook, if you use some of the wording from the handbook,
Sure.
I think that'll protect the area of what we're trying to do.
Right. I would say it's concurrence at this point, based
Yeah, I
on
guess
what you're
that's
saying.
what, is it concurrence or is it the actual board's appointment? That's what we had to work out. If it's concurrent.
If it's concurrence,
Just what it said in there.
right, and we can word it exactly like that, and that still allows you participatory pieces if you'd like to attend interviews, et cetera. So all of that process can remain the same with concurrence, and we're happy to put that wording in there as is verbatim.
And I don't see why it wouldn't be the same word on both sides of the equation.
It can be, yes.
I'm having a problem with this person, and I may have to take action.
Right, if we look at firing or termination, it's with your concurrence, and that does follow your SOP at this point, and allows them to appeal to you. If if you go in the other direction, we do have to have another arbitration process.
How many county employees do not have the right to appeal?
Every.
Under what type of employment agreement do they not have that right to appeal?
Your county administrator right now is the only point. Well, we're talking county employees underneath the Board of Commissioners, no elected officials or any of that.
That's right, because we.
Correct. But just to make that clear, but your county administrator is the only one that does not have appeal rights unless you write it into the contract. So,
So for the employees that are at sheriff's department, how does that work?
the sheriff has his own standards of practice, and they can go through a grievance process with him.
Do they have a right to appeal to the Board of Commissioners?
Yes, they can, but technically they should go through his standards of practice and procedures
I
first.
just don't understand the law. I
Mm.
was curious.
He has, as I said, he has his own standards of practice and his own grievance procedures. He aligns with our standards of practice, but I do have copies of both, and there are some differences. And he also aligns with the state of Georgia for their certifications, et cetera. So,
Do the other elected officials other than himself also have separate standards like that?
no, some actually go directly to your standards of practice and sign that, have their employees sign to your SOP, and they can change that at any time. Anytime a new elected official comes in, they of course can accept or deny. I can tell you right now that the clerk of courts, magistrate court, probate, all of that go right with your standards of practice. And they have signed that agreement, and their employees have a copy of your standards of practice.
I got one more.
What is,
Page 9 of 10, I guess it's the sixth sentence from the top, right above additional functions. It says, direct and supervise the county clerk and so and so. You need to do away with direct and supervise the county clerk. It should be assist the county clerk.
Okay.
You should not have any authority over the county clerk.
Or support, something like that. Yeah.
And it
Assist or
reads what,
support?
Support and a county clerk, something like
Let's
that.
think about
Assist.
that.
I don't know about that.
It shouldn't be supervised, that's for sure.
Because your report's done.
clerk does not, the clerk does not work for the administrator. She's on her own.
When they work together, but right.
Well, it reads in there, they will assist them in doing all this stuff, not supervise them,
And certainly not direct.
and not direct.
Okay.
So who does direct?
Coordinates.
Coordinates is a great word. Coordinates activities, but does not supervise or direct.
Who does direct the clerk?
The board.
The board.
As a whole.
As a
Of
whole.
us as a whole.
Okay, so we got to give her any instruction, we need to have a meeting, get together,
And
and
that's your job.
The chairman,
We don't.
and in that case, sets the agenda.
well, that's why I'm asking.
Okay, when you go to this agenda, she's very much involved in it. And the administrator, he can assist her in doing this agenda.
Coordinates.
But he can't tell her what she's got to do in it. She's one, she works for us. If he doesn't like what she's doing, then he can come to us and say, look here, I can't get any help out of that clerk. She's over there outside smoking and doing something. I can't get no work out of it. So that's his job. That's our problem.
You're gonna have to quit talking to Lana.